Morning everyone, welcome to today's Junior Real Estate Forum 2023 update webinar. Thank you all for joining us today. My name is Kate Ruston and I'm an associate in the commercial real estate team at Irwin Mitchell. I'll be chairing today's session. Alongside me I have Rachel from our disputes team, Victoria from our planning and environment team and Sean from our construction team. They will introduce themselves as we go on. The format of this webinar will be us talking you through each of our topics with an allocated space for questions at the end. If anyone does have any questions during the webinar, please do post via the Q&A box on the top of your screen and we'll try to answer your question if we can. Whilst we may not get to all of the questions, please do feel free to drop me an email at the end if there is a particular question we aren't able to answer. Once the webinar has finished, if there are any topics you would like to hear about in future webinars, please do email me and we can consider these for future events. I'll kick off the session and I'll be discussing the impact of the recession on corporate occupiers with a focus on offices. Please can you move to the next slide? So, as we all know, the way we work has changed drastically over the last 3 years. This is largely due to COVID. In the last 12 months, around 75% of UK companies have changed the amount of office space that they occupy or are planning to change it in the future. Generally, businesses are either drastically reducing or increasing their space. It seems that now the new normal is hybrid working. This seems to be the way that the majority of businesses want to operate going forward, with some even trialling 4-day weeks. Unfortunately, I do think the legal sector would have a long day to go towards 4-day weeks. Whilst we are seeing some businesses allowing more flexibility, some businesses are concerned about productivity. In some cases, levels of productivity have been reduced, and this is largely thought to be due to home working. I'm sure we've all had those quiet Friday afternoons. With rents increasing and the amount of unused office space also increasing, businesses and landlords are looking at more innovative ways to attract workers back into the office. I'll briefly discuss movements in the market and what the future of the office may look like. Please can you move to the next slide? So we recently carried out a survey of over 500 corporate occupiers, which was able to give us a good overview of changes in the markets from tenants. I won't go into too much detail here, but we will email each of you a copy of this after the presentation. The main takeaways are that there is a need for flexibility. There are more businesses now looking at co-working spaces like WeWork, for example. If there are only, say, 30% of the workforce coming into an office on a certain day, there is no need for an office big enough for all employees. There's a need for quality. Businesses want to ensure that their offices are fully kitted out and that are a place that staff actually want to spend time in to make the costs worthwhile. This is reflective of businesses prioritising recruitment and retention in what is currently a very competitive job market. There's a reduced interest in long-term leases. This is likely to be due to costs and uncertainty of the market and the rising cost of inflation. Tenants are more interested in sustainability and environmental efficiency and are now willing to share the burden of costs with landlords. I will discuss this a little more shortly. Of course, where tenants are moving, this means that they need to be thinking about exiting their current leases and entering into new leases. Please move to the next slide. It's important to consider the exit formalities, which can often cause issues for businesses. For example, where a tenant is exiting their lease pursuant to a break clause, have all of the conditions been complied with? Have the notice periods been observed? It's definitely sensible to instruct a solicitor in these circumstances. Also, does the business need flexibility on timescales? Often landlords will consider short-term extensions, but businesses need to ensure that they start discussions with the landlords early. Are there dilapidations that need to be dealt with? Rachel will touch on this a little later. There are also important considerations when taking a new lease. For example, rent reviews. Tenants need to check the rent review provisions carefully. There are different types of rent review and some can involve complicated calculations. The most common rent reviews are open market reviews and reviews based on RPI and CPI. Where there is a substantial rent, it might be worth considering instructing a surveyor to confirm which type of rent review will work out more favourably for you. Service charge. Tenants should ask for previous year's accounts and budgets if these are available. Tenants should be asking whether there are significant works or unusual expenses coming up and checking whether the landlord has a sinking fund to cover these or whether these could be demanded in the future from the tenant. Fit out works and timetable implications. Start to consider the current state of the new office. Do you need to do a fit out? If so, is the landlord willing to allow you to do all of the works you want? Is the landlord willing to offer a rent-free period? And importantly, break rights. You should ask for break rights if the landlord is not willing to compromise on the length of the lease. That way, if it becomes unviable to stay at the property, you do not have to stay for the whole of the lease term. Check whether the conditions are unreasonable. For example, a tenant returning a property to a landlord with vacant possession used to be a very common break condition. This is virtually impossible to comply with, as this could mean that leaving even a paperclip on the floor could amount to a breach of this condition. The market has moved to free from occupation as a more reasonable condition, and this is why it's sensible to always instruct a solicitor. Please move to the next slide. As we have discussed some of the legal points, I think it's also good to think about some of the commercial points. I think we're more likely to see serviced offices like WeWork in the future. Currently in London, 8% of the office market is serviced offices, but this is expected to increase to around 28% in the next 5 years. As tenants are likely to want better quality offices, there will be refurbishments of existing real estate and the competition between new Grade A offices will increase. Landlords should think about repurposing existing empty space. In relation to new leases, we're likely to see much more movement to short-term leases for 5-year terms and under. These are also likely to include rent-free periods and service charge caps to help tenants with the costs of energy. Environmental, social and governance, or ESG, is likely to become a big focus. It seems to be the word on everybody's lips at the moment. Landlords will come under pressure to be more aware of ESG, and tenants will be looking for spaces that encompass ESG policies like employee welfare, with a focus on hygiene and welfare offerings such as showers and massages, offices that are environmentally friendly, perhaps have statements about carbon emissions, spaces that focus on sustainability and green initiatives, spaces that comply with regulatory requirements, and landlords will have to comply with minimum energy efficiency standards. Landlords will also need to be aware of cladding, which Sean will discuss further later. Please move to the next slide. I thought it would be useful to show you a case study which implements some of the concepts I've discussed, and Zoom is a fantastic example of this. In 2021, Zoom's workforce doubled, and this meant that they needed more space. I'm sure we all partook in some of those Zoom quizzes back in the peak of lockdown. So they needed to do something quickly. Zoom initially launched a couple of new pilot offices around the world, with one being in London to test out new strategies. By doing this, they were able to optimise the future of their office space. So I've got some pictures on the slide taken from the Zoom offices. So Zoom essentially created a new approach to their existing offices, which had previously been focused on maximising desk space to cram as many employees in as possible. They did this by creating smaller dynamic hubs in key cities, for example, London, Paris, New York. Some of these were focused on collaboration and some were focused on client meetings. They also ensured that all offices had the key technology to create the best employee experience in every office. They ensured that offices had more focus on health and well-being, for example, including cafes and restaurants, yoga classes, workout spaces, relaxation areas. They also redesigned existing spaces, ensuring that all dead space was used, and reused existing furniture to create new spaces to keep costs down. Zoom also focused on creating 2 types of meeting space, formal and informal. There was also a big push on reinforcing company culture to get employees back into the office, but allowing them to do this on a hybrid basis. This allows better connection for employees and more purposeful trips to the office. I think this is a really good example of the new type of office. Thank you for listening. I'll now hand over to Rachel.
Thank you very much, Kate. My name is Rachel Belinfanti. I'm a lawyer in our real estate disputes team in London. We deal with a huge volume of landlord and tenant dispute matters. As Kate mentioned earlier, at the moment we're seeing a lot of commercial tenants exercising their break options or just otherwise seeking to end their leases early. And therefore reinstatement's a bit of a hot topic for our team. So given that reinstatement is often quite contentious at the end of the term, I thought it'd be helpful to discuss it at this forum. I know that we've got quite a few surveyors in the audience today, so I thought it'd be helpful just to set out what we do really as lawyers when we're considering and advising on reinstatement obligations. At this point, I'd also flagged that this presentation and forum is about commercial property only, and residential property is slightly different. So I think the intention behind having an obligation to reinstate comes from the fact that the landlord doesn't want to be left with property in an unlettable state at the end of the term. Tenants are therefore required to put the property back into the state agreed with the landlord at the end of the term. And in this forum, I'll focus on the obligation as it affects the end of the term. However, I think it's worth a reminder that's important to ensure that the lease is drafted so that the obligation to reinstate is clear to both parties prior to entry into the lease. So when we are first instructed, we first identify the relevant clauses in the lease. We check whether there are any licenses for alteration, as they may affect the relevant obligations. Alterations covenants are essentially what we're looking for, as they restrict the tenant from carrying out alterations to the premises, and then breach of these covenants at the end of the term of the lease then leads to a claim by the landlord for terminal dilapidations. So these alterations covenants, they could be absolute covenants, and that would mean that they prohibit alterations in all circumstances, or they could be qualified covenants, and that means that they prohibit alterations but without the landlord's consent. So there are circumstances where there would be alterations which are permitted subject to the landlord's consent, which often should not be unreasonably withheld. So we need to see, firstly, is there an obligation? Well, landlords want to ensure that any alterations made by tenants can be reinstated by the end of the lease, and that usually requires removing the alterations made and putting the property back into the condition it was, either prior to the alterations being made or to a specific standard agreed between the parties. As mentioned, the starting point is to check the lease and any licenses for alterations to determine the relevant covenant containing the obligation to reinstate and any other relevant clauses which may play into that. So, for example, that might be the covenant to yield up, which requires tenants to vacate the premises and leave it in a particular state, or it may be found within a covenant to repair. I think it's important to note at this point that there is a distinction between a covenant to repair and a covenant to reinstate. This difference is important, although they appear quite similar on the face of it when considering the landlord's damages for tenant breach, and that's something that I'll come on to discuss a bit later. Without an express obligation to reinstate being in the lease, the tenant's alterations essentially become part of the premises. In certain circumstances, there may be other relevant clauses in the lease which may be relied on to require the tenant to leave the premises in a good repair and condition. However, it's better that there is just an obligation to reinstate which could be relied on, an express obligation, as that's much more straightforward to then enforce. So next slide, please. So as I said, we need to check with the lease to see whether there's an obligation. We also need to check the lease to see whether the notice of reinstatement is required to be provided to the tenant by the landlord. If so, notice has to be served at least before the end of the term, if not earlier, as I'll probably come on to shortly. Otherwise, the tenant wouldn't be required to reinstate, as I said, and the landlord couldn't even pursue the tenant for damages. So we would suggest that best practice is to serve notice anyway, even if there's no specific obligation on the landlord to do so. So the lease may also specify that notice is to be provided in a prescribed form, so it's definitely worth checking, because failure to provide notice in that form may render the notice invalid. It's not often that you come across this, but if so, then it's not a risk worth taking. Notices often append schedules of dilapidations to them, and I'm sure many of you are aware what they are because often you're the ones drafting them for us. However, for anyone who's not come across one before, essentially a schedule of dilapidations is a schedule served by landlords on the tenants, which sets out the items of disrepair at the property caused by the tenant's failure to perform its repairing and reinstatement obligation. And we usually see that for each item of work required, i.e. each item of disrepair, the relevant clause as to repair is identified so they can identify how that disrepair falls into, is covered by the lease. This is important should the landlord issue a damages claim, as they're calculated differently for disrepair and failure to reinstate. The damages are calculated differently. Just to flag that on its own, a schedule itself isn't usually sufficient to give notice to reinstate. That's why we normally draft that separately and append the schedule to the back of that notice. At the timing, the lease may contain a deadline by which notice to reinstate is required, and that would have to be strictly adhered to. Again, if they're not served within that specific time, then the notice would be invalid and the tenant wouldn't be required to reinstate. So as I said, often notice of the requirement to reinstate is included when we serve the terminal schedule of dilapidations. However, that notice to reinstate doesn't actually need to include the schedule if it's not prepared yet. And often we do serve notice prior to having the schedule of dilapidations just to protect the landlord's position immediately. And then the schedule of dilapidations quantifying that liability can be served at a later date. If no deadline is specified in the lease, then the best practice is just to serve it as soon as possible before the end of the term, excuse me, both to protect the landlord's position and to enable discussions to commence with the tenant to see what the tenant's going to do really, and to enable the tenant sufficient time to undertake the works rather than allowing them to stay in occupation after expiry of the term to complete the works that were required. So next slide, please. After serving notice and the schedule of dilapidations, there are a few options available to tenants. The tenant could either do the works. I mean, that may seem initially like a more straightforward option. Yeah, I know what needs doing. Let's just tick them off. We'll get a surveyor, we'll get the building contractors, and we'll get all this done ourselves, maybe cheaper. So there are benefits to doing it that way. However, that does carry its own risks because although it may appear that the works have been identified by the schedule of dilapidations, you can't guarantee really that you've covered all the works that the landlord actually requires if they don't fall within that. And the other major risk is whether the works are actually completed on time before the end of the end of the term. You know, you don't want a half-finished property and then you've not agreed anything with the landlord. So yeah, there are risks involved with just doing the works themselves. Tenants can commence negotiations with landlords if they don't want to deal with the liability, don't want to accept the risks of doing the works themselves, and therefore pay a sum to settle the landlord's claim. This may especially be the case if the landlord's planning to alter the property in any event, then they're more likely to agree a figure. They don't actually need the property reinstated. It's just, you know, they do want some sum to be able to do something about the state of the property, but it may be that they'll be able to reach an agreement. Agreements of this sort provide tenants with certainty as to their obligations, and also avoids the time and expense of liaising with contractors, particularly given that lease termination is a busy time anyway, especially if they're relocating or if they're dealing with insolvency measures. And so often, yeah, an agreement to settlement of the dilapidations liability it guarantees certainty. You know how much things are going to cost because there'll be a lump sum that's just paid towards a dilapidations liability, and it's all covered off. And then you know that the landlord's essentially waived any right to you know, claim that you haven't done enough work to the property to meet that obligation. If the tenants don't do the works or come to an agreement with the landlord for a dilapidation sum, then the landlord could issue a claim for damages. Damages for the breach of the covenant to reinstate are calculated slightly differently than you might expect. They're usually granted to the landlord on the basis of the loss that has actually suffered, and that would be the amount of the diminution in value of the property as a result of the tenant's failure to reinstate, rather than simply the cost of the works to reinstate. So therefore, it's the amount of loss due to the failure to reinstate, rather than, well, I said, just the costs of doing those works. I think that's because there are circumstances where the landlord may not intend to do the works at all, or maybe the landlord's claimed for the works which are actually excessive or unreasonable, and therefore shouldn't be given the costs of those. They should only be given the cost of the loss in value of the property. So just in summary, I think it's a reminder that in respect of the obligation to reinstate, first place to look is the terms of the lease. In the last year of the lease, landlords will need to have reinstatement in mind. So I think best to get in touch with us really, and because we might need to serve notice to reinstate quickly by a specific deadline, and that could be imminent. So I think that's everything that I'll be talking about. Thanks very much for listening, and I'll hand over to Victoria, who'll be talking about use classes. Thank you.
Thank you, Rachel. Hi everyone, I'm Victoria Tague. I'm from the Planning Environment team at Irwin Mitchell, and I specialise primarily in planning law. I wanted to speak to you about use classes today, as I believe having at least a basic knowledge of use classes is very important across the real estate sector, and use classes will impact most, if not all, real estate professionals at some point in your career. Next slide, please. Three main examples of this include sale and acquisition, grant of leases, and development. Taking each one in turn, on the sale and acquisition of a property, it is important to be aware of what use class the property is to ensure that it can be marketed and used for the purposes needed. It is also helpful to understand use classes to be aware of the potential market options, as it isn't always the case that a shop can only ever be a shop, for example. It is possible that a property can be marketed to a wider audience if you have a general knowledge of use classes. Secondly, on the grant of a lease, similar to an acquisition, it is important to ensure that your client is marketing and purchasing the property with the correct use class. However, it is also important to ensure that the correct use class is recorded in the heads of terms and lease documentation, both for the freeholder and the leaseholder, and to ensure that this use is permitted by planning legislation. Particularly for the leaseholder, it can be very damaging for a business to take a lease of a building only to find that they cannot use it for the purposes they need. Finally, when assisting clients with development plans, it is very important to be aware of what the current use of the property is in order to understand what is needed to develop it. For example, whether planning permission is required to change the use, or whether there may be easier ways around this which could reduce the timescales for development. I'll touch upon these shortly. Having an awareness of use classes is particularly important in the current economic climate because a lot of clients are looking to protect their investment long term. Where the market fluctuates, it's good to have an understanding of use classes to be able to advise your clients as to the potential options for future development. To begin, I thought it would be helpful to run through the current use classes, particularly as there has been a significant amount of reform of use classes in recent years. There are currently 10 use classes in England. I'll start with the most straightforward ones first, which include B2, general industrial use, B8, which is simply storage and distribution, Class C1, which covers things like hotels, guest houses where no significant element of care is provided, Class C2, which is residential institutions, and includes things for care provisions, including residential schools, hospitals and nursing homes. Class C2A is secure residential institutions, so for example, prisons, detention centres and secure training centres. Class C3 is a regular dwelling house, and Class C4 is houses in multiple occupation. Apologies for this, but I've only noted this morning that there are two other classes which haven't been included on the slide. So just to run through those two as well, I appreciate they're not on the slide, but those are Class F1, which are learning and non-residential uses, including schools, museums, libraries and courts, and Class F2, local community uses, including community halls and things like swimming pools. That is just a brief overview of them. There are other things that are included, but that's a general overview of those use classes. Next slide, please. Now, finally, we have Class E, which has been the largest reform to the current use classes order in recent years. Class E incorporates a wide range of commercial uses, including shops, restaurants, financial and professional services, indoor sport and recreation, medical services, nurseries, offices, and even some industrial purposes. So as you can see, Class E covers a lot of different uses. The majority of these uses were historically all in separate use classes and therefore would have required some form of planning permission in order to change between them. As movement within the same use class is not considered development, a change between these uses wouldn't now necessarily need planning permission. However, this is subject to some exceptions, which I will come on to. When these uses were separate, they wouldn't have necessarily permitted changes without first obtaining planning permission or prior approval, which can take weeks or months. All the while, businesses could have been sat with empty units, and therefore grouping all of these units within one use class allows for more commercial flexibility for businesses and allows businesses to respond more quickly to changing markets and should promote flexible mixed-use developments. Uses within Class E will, subject to some exceptions, still also benefit from permitted development rights, and therefore there is even more opportunity to expand on existing use of property without having to first obtain full planning permission. Which leads me nicely into talking about further extensions the government have made to permitted development rights for Class E properties. Next slide, please. In addition to introducing Class E, the government has also introduced a new class of permitted development, Class MA. This allows a change of use from Class E to Class C3 dwelling houses, subject to certain exceptions and having obtained prior approval from the council. However, the prior approval process is generally much quicker and easier than obtaining full planning permission for a change of use. And again, this is very helpful to developers and property owners, particularly in the current climate, as it allows more flexibility for a property and makes decision making for those particular changes of use significantly less time consuming. Again, this allows businesses to easily adapt to changing markets. Next slide, please. Having said that, we must all tread carefully when considering changes of use and whether they may require planning permission. Whilst it's great news that Class E and the new permitted development rights have brought in a significant amount of flexibility for the commercial sector in particular, it is important to not automatically assume that this flexibility to alter uses will always apply. Before confirming the ability to change use, it is important to check a number of things, including whether the property is subject to an Article 4 direction. These are directions made by a local authority and generally apply to a number of properties, but can also apply to local authority-wide if they are justified. Article 4 directions restrict permitted development rights, for example, rights within Class MA without first obtaining planning permission. These are used regularly by councils, and we have seen a number of councils react to the increased permitted development rights in Class MA by way of introducing an Article 4 direction. In addition, it's also important to check any planning permissions or Section 106 agreements which relate to the property to ensure that there are no restrictions on use in the conditions or obligations. We regularly see conditions imposed on planning permissions in Section 106 agreements which restrict permitted development rights, and in some circumstances I've seen conditions go beyond this and restrict uses completely to a certain use within a use class. This is something I suspect we will see more of moving forward, given the broadness of Class E. It is important to be aware of how these conditions and obligations restrict the use of the property, but also any future development. It is also worth trying to argue against the imposition of these conditions and obligations during grant of planning permission, because whilst they do not seem too much of an issue at the time of grant, particularly as the concern at that stage is obtaining planning permission for the proposed use, they can have a significant impact on future development of the property. It's also important to be aware that a number of previously used class properties have now become sui generis uses and therefore are effectively a new unique use which will always require planning permission to alter. These include things like pubs, bars and takeaways. These properties will therefore no longer have the benefit of permitted development rights to change the use. And finally, it's just important to be aware that although planning permission isn't necessarily required for the change of use, permission may still be needed for any additional works that are required in order to facilitate that change of use. So although you may be able to just push on with the change of use without needing anything, if there are works to the building that would require some form of planning permission, obviously that planning permission will still be needed. Next slide, please. Finally, one last useful point I wanted to highlight was flexible or dual use planning permissions, as this can sometimes be helpful for developers and owners who are not clear as to the best use of a property and may want to simply test the market. A flexible or dual use permission is a permission granted for multiple uses and allows an occupier to switch between those uses for a period of 10 years. At the end of the 10-year period, whichever use is in operation then becomes the use of the property moving forward. This is very helpful as it allows for flexibility between use classes that may not otherwise be permitted without permission. It therefore maximises the market available to a property if the owner can offer multiple interchangeable uses and allows owners to test the market for a short period if necessary before deciding which use is most suitable. Therefore, to summarise, the government has clearly made some changes to use classes which will be beneficial particularly to the commercial property sector, so it's worth having somewhat of an understanding of these in order to best advise your client moving forward. Thank you for listening. I'll now hand over to Sean.
Thank you, Victoria. My name is Sean. I'm a lawyer in the National Construction team. I work in London and I primarily work in the disputes side. So today I'm going to be speaking to you about the Building Safety Act and touching on only a few aspects, given that the Building Safety Act is incredibly large and expansive and affects a lot of areas. So I'm just going to focus on a few areas, but that is of course not everything that is important. So the Building Safety Act received royal assent on the 28th of April last year and has come into force on the 28th of June 2022, which was of course in response to the Grenfell Tower disaster. So some provisions of the Act are already in force, but most provisions relevant to today's presentation do require secondary legislation and will not take effect for a further 6 to 12 months. As I said just before, it's a significant and incredibly large piece of legislation, and it was also drafted relatively quickly for such a large piece of legislation, and anything that's drafted in a rush, a lot of the legwork in the Act is actually left to statutory instruments and amendments to other legislation. So there'll be more of that to come. Amongst other matters, the Act's primary concern is a creation of a safety regime for the development and construction of residential buildings, mainly. It mainly deals with higher risk buildings. What is considered a higher risk building? The definition of a higher risk building changes throughout the Act. Throughout, there is a common theme though that what is considered a higher risk building is a new or existing occupied buildings over 18 metres high or 7 stories or more, which contain at least 2 residential units. I'm going to outline the more broad and significant changes legislation is bringing in, and then touch on one significant aspect which will affect leaseholders. Could we grab a changes slide, please? One of the largest changes is the expansion of duties for duty holders. So this is during the design and construction phase of those higher risk buildings. The government has recently sought feedback on what these changes or expansion of duties would look like. However, it's expected that the new duty holders and their duties would be modelled on the roles in the current CDM regulations from 2015. This will mean those who frequently act as principal designers will have increased site safety duties and a responsibility for what is called the golden thread of information relating to design decisions, particularly for fire and structural safety. What the golden thread essentially means is that there is to be a record of information from the day the building is designed, basically from day 0 until and throughout operation, which contains information relating to fire and structural issues or considerations. This will likely require those who act as principal designers to plan, manage and monitor design work to ensure that it is compliant with building regulations. The Act also provides that building regulations made under the Building Act 1984 may be amended to establish new duties of competence on those carrying out design or building work to ensure that they have relevant skills, knowledge, experience and behaviours. This will result in increased scrutiny on those who work in more general design roles. A particular change and of particular concern to lawyers is the changes to limitation. So the Act extends the limitation period for claims brought under the Defective Premises Act 1972, so that claims arising from historic works have a limitation period of 30 years from completion of those works, and claims relating to prospective works will have a limitation period of 15 years. So parties to works will need to review their document retention policies and their insurance arrangements to reflect these limitation changes. Could we have a changes slide, please? The Building Safety Act has a particular change that I wanted to highlight today, which relates to leaseholder protections for leaseholders who have a qualifying lease. So the Act provides that leaseholders with a qualifying lease will not have to pay for cladding remedial work. So cladding remedial work is defined as removal or replacement of any part of the cladding system that forms the outer wall or external wall system and is considered unsafe. So qualifying lease has a pretty prescriptive criteria. It's a lease for a dwelling in a building which has 2 residential dwellings, at least 11 metres or 5 stories high, self-contained or part of the building, and is a long lease for more than 21 years. And as of 14th February 2022 was the leaseholder's principal home. What is important about the qualifying lease is that it exempts those who hold a qualifying lease from having to pay for remedial work. This is quite different to the position previously where landlords could charge for remedial works through a service levy. So it operates around the service levy as it has originally worked. This also applies to works which are considered significant safety risks. So there's also a separate regime for safety risk works, so not particularly cladding, but other general safety works. One other thing I'd like to point out today, as well as so many other things that the Act controls, is that there will now be a regime for registration of high risk buildings, which is happening this year. So the principal accountable person must register with the HSE their high risk building. All high risk buildings are to be registered from the April 2023 and have a deadline for compliance within 6 months. So that basically gives that principal accountable person until October 2023 to register the building, and not complying with this can have some pretty strict consequences. High risk buildings, which are new builds, cannot be occupied until they're registered. So there'll be a lot of scrambling in the next few months, I think, to make sure that compliance can be achieved. Thank you, and I'll hand back to Kate.
Thank you everyone for your insights. They were really interesting. I thought I'd like to move on to the questions that we've had in. So I think the first question is for Sean, actually. So who is responsible for paying and fixing the defects under the new Act?
Generally, it's the building owners who are placed with the greatest share of liability under the Act. As I was saying before, like despite what leases generally say in service levies, like a qualifying lease may mean that a tenant might who might have previously been required to pay may be exempt from paying. The Act does bring in what's called a remediation contribution order, which is a new order which a court can make relating to the funding of remedial works for certain defects. So there's lots of qualifications of who can make an application for such an order, but they're generally made against a landlord, and that could be made against a landlord like a previous landlord, so one back in time, a developer, or any of the persons associated with those parties, but generally it's the building owners who are facing a greater share of liability.
Okay, thank you, Sean. So I think the next question is for me. So what do you think the biggest reason that people are downsizing offices is? So I'd have to say that there are lots of reasons, but the biggest has to be the energy costs, which is closely followed by remote working. So businesses just don't want to pay the rising energy costs for half-full premises. So the next question is for Rachel. So this says, we are tenants of retail premises and are in the process of vacating one of our units at the moment. We have asked our landlord to let us know ASAP how they want us to leave the property, but they haven't confirmed and haven't responded to our emails. What can we do, and how do we know whether they want us to or not?
Thanks for your question. Well, firstly, I think we would just need to review the lease. I mean, that's a fundamental starting point, just to see whether any obligations to reinstate or yield up, any provisions requiring the landlord to provide notice. And if the landlord is required to provide notice, then when by. Unfortunately, if there's no express requirement or deadline for the landlord to do that, they may well not respond. Or may respond really late, because they wouldn't be obliged to respond to you early, unfortunately. I think what we'd really need to do is just review the lease, review the facts, because it really does depend on a on a case-by-case basis as to kind of what you do next and next steps really, and to try and get the landlord to engage. And we'd be very happy to pick this up if you'd like assistance. Please just email me directly after the session and I can pick up with you then.
Thanks, Rachel. So the last question is one for Victoria. This is one we get asked a lot actually. So which use class does Airbnb usually fall within? Is that a hotel?
Yeah, so thanks for that, Kate. Yeah, it's a question that we get asked quite a lot. It is a tricky one. It's very much dependent on the individual property. Clients quite often get in contact with us asking us that specific question because it can honestly apply to a number of different use classes. So an Airbnb can sometimes be classed as C3, C4, C1, and potentially more. It just depends on a number of factors related to that specific property. So things like the number of bedrooms, the size of the property, the number of nights that it's being used as an Airbnb, where the property is, etc. So it can fall within a number of different use classes, which we would need to assess basically on the individual property. There's also certain restrictions in London that are more extensive than other areas of the country, or more prescriptive than other areas in the country. So yeah, from our point of view, it's a tricky one for everyone. It's something that we all have to wrestle with, and it just depends on specifics. So if there is something that we can't say specifically in relation to an Airbnb, by all means get in touch and we can have a chat about that. But yeah, it can vary from property to property.
Thank you, Victoria. So I think that's all the questions we have time for today. So I just want to finish by thanking everybody for sharing their insights and our audience for taking the time out of their day today to join us. Our contact details are on the slides. If you do want to get in touch, feel free to drop us an email or a call. You can also visit our website, which is just irwinmitchell.com, for the latest guidance, and sign up to any upcoming webinars as well in the future. Just to mention that there is a feedback form. It should be, I think, in the Q&A box. So please do leave us feedback, good or bad, just so that we can make future events better. And we look forward to seeing you again in the future.